Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation and Critical Legal Content, custom content for law firms and litigation service providers, and the newly formed VLEX Fastcase, your world of legal intelligence, and our friends at Law Street Media. I'm your host, Tom Hagee, litigation content producer, an enthusiast, and an average bongo player. Contact me if you have an idea for an episode. In addition to often being polite, I'm always looking for new twists on the law, whether it's a new regulation, legislation, or an important new opinion. Or it could be a development in the world that will test existing law, or anything you're dying to share with other litigators, organizations, or individuals. And if you like what you hear, give us a rating. That always helps. And now, here's today's episode. So this episode, we're going to talk about what old Tom Jefferson had to say about patent law, among other things. Here, you just thought he was writing declarations of independence. That's all I thought he did. No, that's not true. I believe he was also president. And why can't a monkey copyright his own selfie? It seems patently unfair. Or is it patently? We won't discuss that. And there are issues raised, of course, when artificial intelligence, when a machine driven by artificial intelligence cooks up an idea. Specifically, there was one inventor who tried to throw a monkey wrench into how Patent and Trademark Office determines inventorship. We're going to talk about such AI engines, one named DABUS, which stands for a device for autonomous bootstrapping of unified science. There you go. Everybody should have one if you don't already. How does an invention come about? Can it be conceived solely in a human mind? And what did a federal court recently have to say about some of these issues? So joining me to discuss these questions and more, because there's always more, is Robert A. McFarlane, an intellectual property litigator and registered patent attorney, and a partner with Hanson Bridget, LLP, in San Francisco. Rob chairs the firm's technology practice and co-chairs its intellectual property practice. He focuses on patent infringement and licensing disputes, trade secret misappropriation, all the good things, technology-related commercial matters, and software performance disputes. Counsels clients on a range of IP matters. He's argued, of course, cases around the country, but he's also been retained as an expert on American patent law before the High Court of England and Wales, and has handled matters before the International Trade Commission. Rob teaches patent law as an adjunct professor at the University of California College of Law, San Francisco. It's formerly the Hastings College of Law. He previously taught patent, litigation, and IP courses at Golden Gate University School of Law and copyright law at Santa Clara University School of Law. He earned his JD from the University of California College of Law, San Francisco, again, formerly Hastings, and his BAS with departmental honors in industrial engineering and political science from Stanford University. And with that, here is my interview with Rob McFarlane. Hope you enjoy it. Rob McFarlane, thank you very much for speaking with me today.
Great to be here.
Before we get to the 21st century, tell us about Thomas Jefferson and Enrico Fermi.
Well, sure. I mean, it's interesting. Patent law always focuses on cutting edge issues. Today it's everything from artificial intelligence to the new CRISPR technology that's used to actually edit DNA sequences. So everyone thinks of these cutting edge deals. They think about practicing patent law, dealing with everything that's new. But really, the foundations of our patent law are as old as our country. It's actually in the Constitution. All patent lawyers like to open their arguments to a jury with a reference to the Constitution. The Constitution actually says Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. So it's in the Constitution. And so it's at that time, Thomas Jefferson, all the founding fathers are, thinking about patent law and a few other things, I guess. But, of course, for patent lawyers, the most important thing is patent law. Mm-hmm. And so Thomas Jefferson actually wrote the first paragraph of the patent statute, and it defines what you can patent. And in Thomas Jefferson's words, you could patent a new, and he said, art, machine, manufacture, or composition of matter. And that phrase is still in the patent statute with one phrase, with one word changed. Now the patent statute says you can patent any process machine, manufacture, or composition of matter. So those are the four things you can patent. So every utility patent falls within one of those four categories. And then the courts have carved out exceptions to those. You can't patent a law of nature, and you can't patent a natural phenomenon, and you can't patent an abstract idea. And so that brings us to the question of Enrico Fermi. And so under those, when you think about the law of nature, Einstein could not patent E equals mc squared. That is a law of nature. It's been there for eternity. It's there for anyone to discover and use. And so that law of nature can't be patented, but an application of that law of nature can be patented. And so that's where Enrico Fermi came in. Whereas Einstein could not patent the law of nature, Enrico Fermi could, and he did patent nuclear reactors that use that law of nature. And so that's what you can patent. You can patent an application of the law of nature, an application of a natural phenomenon. You just cannot patent the law of nature itself.
So coming forward to the case we're going to talk about is Thaler versus Vidal, was whether an AI system could be listed as an inventor. So if you could give us a snapshot of what the issue was there, including some of the facts presented and the parties, and who's Thaler, what is it Dabus or Dabus? How do you say that?
I've heard it Dabus is how
Dabus. Okay,
yeah.
Option 3. Okay, go ahead. Tell us about that.
And so Stephen Thaler is an AI research and artificial intelligence researcher, and he's been filing this and other cases trying to establish what legal rights are in inventions and creations of AI systems. And so in this particular case, he had two inventions by DABUS, and DABUS is an artificial intelligence engine, and DABUS stands for Device for Autonomous Bootstrapping of Unified Science. That's why you call it the acronym DABUS. Under the U.S. patent system, the inventor gets the patent. And up until AI system, it's always the human being that conceives of an invention is awarded the patent. And so conception is the mental part of invention. It's creating in your mind, in the mind of the inventor, the idea of the patented invention as it is, in its full and complete form, as it's thereafter to be used. And so, that mental act of conception generally earns a patent. Mm-hmm. And so the interesting thing about the Thaler case is Thaler put in affidavits into the U.S. Patent and Trademark Office and subsequently in court that the inventions at issue had been conceived of entirely by DABUS, this artificial intelligence engine, without assistance or direction from a human being. And that was the record. That wasn't challenged. There was no further facts of that. But for the court decision and the USPTO decision, that was the fact. And so they took it that DABUS had created these two inventions. And the two inventions at issue were two very different things. One was called a device and method for attracting attention. Think about like if a fire alarm goes off in a building, you see a flashing light, on the little fire alarm. But the idea of this invention is that if it's a very chaotic environment, smoke, noise, fear, if it's an actual fire, just a single flashing light doesn't attract human attention very well. And so the idea of this invention was that if you have the light source pulse at a specific frequency that's tuned to human brainwaves, it will attract human beings' attention better. And so according to the application, DABUS had used fractal mathematics, fractal dimensions to synchronize the frequency of that flashing light to human brainwaves, thus making it better at attracting attention. But that idea, the frequency, the method of flashing, how it goes about interacting with human brainwaves was calculated entirely by DABUS, no human being intervention. So according to Thaler, DABUS had invented that. Okay. And then the other thing DABUS invented, this isn't quite as abstract, it's a food container. Okay. And again, it uses fractal geometry. And so the idea of this, if you have a 6-pack of Coca-Cola or a 6-pack of Budweiser, you have to have the 6-ring binder, that you put the cans in. So that creates waste. And so the idea here is, well, if you have a fractal design for a container, they have edges that can then be used to interlock with each other. And so you can have interlocking food containers. And so that's that invention. And again, Stephen Thaler said, my AI engine, Dabus, had created this design all on its own, no intervention from me, so it should be the inventor.
Okay.
And so the issue in the Thaler versus Vidal case was, can Dabus, an AI engine, be an inventor?
What arguments were presented in court for and against naming Dabus as an inventor?
Well, for we talked about the Constitution a moment ago, and so that's what Stephen Thaler relied on. He said, you go back to the idea of what is the purpose of patent law? What is the purpose of awarding patents? And it's to encourage inventions. It's to encourage people to invest in the R&D, to create those inventions. And then the purpose is to permit their disclosure. If you look at the difference between patents and trade secrets, trade secrets you can't disclose or they lose their value. Anybody else can copy a trade secret if you disclose it. Whereas patents give you rights against anyone in the marketplace. If you have a U.S. patent, nobody can practice your patented invention within the United States. And so if you award a patent on a valuable invention, then it encourages the research and development to make that, and it encourages its commercialization, and it encourages its disclosure. And so Stephen Thaler said, "Look, this is a valuable invention. I'm using an AI engine. It has created this valuable invention. I want to commercialize it. I want to disclose it so other people can build on it. And that's what the patent system is for. And so it makes sense to award a patent, even though the inventor is an AI engine."
Okay.
So very policy-based arguments. The Patent and Trademark Office, the USPTO, argued that's all nice, that's all fine. We're not arguing with the statutory purpose or the constitutional purpose of patent law, but the patent statute says whoever invents. All the other patent statutes refer to the inventor as an individual. They refer to it with personal pronouns. An inventor is he or she or they, if there's more than one inventor. A corporation cannot be an inventor. All the patent rights has to go back to the human inventor, the individual inventor, or if it's, a joint invention, the handful of inventors. There's nothing in the patent statute that says a non-human can be an inventor. So the Patent and Trademark Office, the government just argued, kind of dryly, based on the language of the statutes. It says a person for all intents and purposes. Dabus isn't a person, so Dabus cannot be an inventor. And so those were the two arguments on either side.
So where did the Federal Circuit come down on this?
They came down with the government, and they said, we're not going to get into the metaphysics of the nature of an inventor, the nature of an artificial intelligence. We're not going to answer any question of what rights, if any, an AI system might have. We're just going to look at the statute. And they said, going through all the statutes, they kind of followed the government's argument. It refers to a person. It refers to a natural person. And so that's what they ruled, just as a matter of they didn't answer the big questions. It's just strictly, what does the statute say? What has Congress written in the patent statutes? And it requires a natural person to be an inventor.
Okay. So that's inventorship. But you also wrote that the court itself invented something, a new category of inventions. What do you mean by that?
Well, in this case, so if you have a patent that has an artificial engine or artificial intelligence engine as a inventor or the inventor, under this statute, it just can't be patented. So it's kind of an orphan category of inventors. It may be a valuable invention, but it cannot be protected through the patent system. And so really this decision gives rise to the question of, okay, if you cannot patent that invention, how do you go about protecting it? How do you go about commercializing it without the ability to patent it? So really it gives rise to that whole new category of things that companies will have to think about.
Okay. So when I talked to you about this before, I was wondering, not that anybody would endorse this, certainly not you or I, but you're supposed to divulge everybody's role and how in the process that you use to come up with an invention or develop an invention. But what's to stop somebody from saying AI didn't have a role or just not mentioning AI it was used?
I guess two things really. One is whenever you file a patent application, you do sign an oath under penalty of perjury that you are, in fact, the first true and sole inventor. And so if, in this case, Stephen Thaler saying that artificial intelligence agent created this, conceived of this invention, if he signed that oath, it wouldn't be true. So, there is, one issue there. And the second issue is that if the patent does not name the correct inventor, then it can be invalid. And so if you had a patent that actually was conceived of by an artificial intelligence engine without input from a human, and you put a human being's name on there, that human is not technically the inventor. Mm-hmm. If you sued anyone on that patent, those facts would come out during the litigation, and then the accused infringer would be able to argue that the patent is invalid for failure to name the correct inventor.
If you didn't show your work already, you really have to show your work if somebody challenges.
Right.
What do you see the pros and cons of this ruling? Do you think this is good for innovation?
Well, I think it's a limited ruling in its scope because, the facts before the court were very, kind of artificially presented by Stephen Thaler. He said there was no human input into this invention. And so, on that, what that doesn't answer is, okay, if a researcher is using artificial intelligence as a tool during their research, how far can you go in patenting that? And I think as long as the human, like today, you've got, any number of inventions where you're using computer modeling, just anything from a wind tunnel to, computer modeling in pharmaceuticals, anything. And the inventor is actually using those pieces of software as a tool for their inventive process. And so there's nothing in Thaler that says you can't do that using AI, as long as the inventor is still conceiving of the idea, directing the AI in its research. The human is still, the inventor under the statute, I would argue. And so Thaler applies to the extreme positions. And so it doesn't really take away the ability to patent inventions that where human beings are using AI as a tool. Is this in that narrow context, is it a good decision or a bad decision? And we really have to go back to what we talked about. What is the purpose of patent law? It's to advance technology. It's to encourage research and development. It is to encourage the disclosure of inventions, the commercializations of inventions. And so there's always a balance there. You want to give enough patent protection that encourages those activities, encourages research and development, but you don't want to give so much patent protection that it discourages other companies from conducting research, from commercializing property. And so if you go back, like around the turn of our century, around the 2000s, there was the internet boom, and out of the internet boom became a large numbers of very basic patents having to do with internet, having to do with computer networks. And then all of those companies, or many of those companies, dissolved and failed in the dot-com bust, but their patent estates persisted. And so a lot of those patents were acquired by non-practicing entities. Targets of non-practicing entities call them patent trolls. That's a little bit of a derogatory term in some circles, but you can call them non-practicing entities, and NPEs or patent trolls. And so there was a lot of writing, a lot of argument, even in Justice Breyer wrote some concurring opinions talking about this issue, where you awarded so many what were deemed low quality patents that came out that actually discouraged inventions, because non-practicing entities particularly could then sue practicing companies and extract royalties from them based on patents of limited value. And so the balance is, okay, you don't want to give so many patents that they become a drag on companies that are creating products or creating services.
Yeah.
That's too much patent protection, too little patent protection,
right.
And it undermines research and development, research. And so in this, you have to look at, how do you get the balance right here? Is denying, kind of from a policy perspective, is denying all patentability of things of inventions created solely by AI. Is that too far? Or if, as long as the person who's using the AI is directing it, then you can give, and using it a tool, then you can give the patent to that person.
Yeah.
And so I think, at the end of the day, I think it's probably going to, end up as a balance between those extremes of denying. Let me say that part again.
Sure.
At the end of the day, it's balancing the protection of the patentable inventions. I think in almost all cases, you're going to have a person directing the AI and directing what the AI is doing and using it as a tool, just like you're using software modeling technology today. And then that person will still be an inventor. If there are situations as AI advances that it actually is sole inventor on patentable projects, then I think you have to look at, does the patent statute have to be tweaked a little bit so that the AI can technically be the inventor, and then the ownership of the patentable invention rests with the individual or the company that is controlling, funding, operating the AI.
Okay. Well, you led into the next question around working under the direction of an inventor. And then you also had brought up the concept of work for hire in the copyright realm. What more can you say about those?
Right. And this is what's kind of interesting in one of the differences between patent law and copyright law. So in copyright law, if you are an employee working for a company, it's your copyrightable work that you create in the course of your employment is considered a work for hire and belongs to your employer. Patent law is very different. There is no concept of work for hire in patent law. The property ownership of the invention rests with the human that creates the invention or conceives of the invention, absent a written assignment. And so if you look at tech companies, there's always an inventor assignment form. They sign, it's usually in the employee handbook and the employment contract, and it says any inventions you conceive of during the course of your employment here belong to the company. And you hereby assign those inventions to the company, and you will assign, you'll basically execute an assignment form when the time comes for it.
Right. So the human being is still the inventor, but the ownership can go to the company or to whomever they assign.
Exactly.
I gotcha.
Exactly. And so the question of inventorship is who actually conceived of the invention, who actually conceived of the idea. And then the ownership is who has legal title to that invention. Has the inventor effectively assigned it to a company? If they have, has that company assigned it to somebody else, or who actually has that legal title?
I gotcha. All right. So as you said, this case, Thaler, was in the patent context. Did you want to say more about AI in the copyright area? Because we're seeing a lot of that come up with authors and folks like that. So how might Thaler be applied in that context? And most importantly, I want to ask about the monkey selfie. So if you could get into that.
Well, it's exactly the same issues that arose in this. In the Thaler case, you have an artificial intelligence engine creating a patentable invention, but there are instances where an artificial intelligence engine generates a work that, if it was created by a person, would be copyrightable. And Thaler, has really been trying to push the law in this area, not only in patents but in copyrights. And he had another artificial intelligence engine that created an image called the Entrance of Paradise. It's a very beautiful floral scene. It kind of looks like a railway spur kind of disappearing into this very peaceful setting. And he tried to get a copyright on that. He tried to register it with the U.S. Copyright Office. And the Copyright Office came to a very similar conclusion. It said, under the copyright statute, you have to have a human author. You cannot register a copyright for something that is not created by a human being. Mm-hmm. And so the history on that is originally photographs. There was a big dispute back in the 1800s whether you could copyright a photograph, because the theory was that a photographer is just putting the magic box on its pedestal and opening the shutter,
right?
And it's just a mechanical act, that there's no act of authorship in that. I think anybody who's ever taken a picture knows that more goes into taking a picture in terms of framing, composition. And so the courts ultimately decided that absolutely, it's that's why people, will pay thousands of dollars for beautiful or artistic photographs. So the courts eventually came to that view that said, well, there is a human author to a photograph if a human takes a picture of that. And so the case came down, the monkey selfie case, just a few years ago, came down and answered the question of whether you have to have a human author. And so this made all the rounds on the internet, and many memes were done about it. But you've got Naruto, the macaque monkey, took a wildlife photographer's camera and snapped a really nice selfie of himself. It's very dramatic, very handsome photograph of this macaque monkey. And so a wildlife welfare organization took up his case and said, Naruto should be the author. He took this picture. Naruto should have the copyright on this. And the Ninth Circuit Court of Appeals here in California just came down and said, well, Naruto is not a human. You have to have a human as an author, or you can't get a copyright. And so, again, just very cut and dry. It's just a line in the sand that you cannot cross. And so, that decision was relied on when Thaler tried to copyright his image of the entrance to paradise. The Copyright Office and later the courts just said, look, there's no human author. You cannot get a copyright in the absence of a human author. Okay. And then so the subsequent decisions from the Copyright Office kind of take up the issue. Okay, so you have a situation where a person is using AI as a tool. Person's relying on AI for some things, but contributing other things. And so there was a case that had to do with an author named Christina Kashtanova, who had created a graphic novel called Zarya of the Dawn. And to do that, all of the images in the graphic novel had been created by an artificial intelligence. One of the, I can't remember which one it was, but it was, one of the standard image generating AIs. And she worked for months, really to get the texts, the prompts right and everything, just to get exactly the images she wanted. Mm-hmm. And then she took those images and arranged them into a graphic novel and then put her own human generated speech bubbles mm-hmm. into them. Mm-hmm. And so what the Copyright Office said is, look, the images themselves lack human authorship. So you cannot copyright the images themselves. But you, Christina Kashtanova, took an authorship step in arranging them, curating them, putting them into the form, the order, the arrangements, the sizing, and you put the speech captions into them. And so there is a limited copyright then on the compilation as she put it together, and then on the human generated speech. And so again, there's kind of the balance of anything that's purely generated by AI can't be copyrighted, but the humans, basically steps of authorship, the humans compilation and use of that is subject to a more limited copyright protection.
Right. Okay. I kind of remember that coming up in the context of like directories and things, mm-hmm. That information's out there, but you've also added value to it. You've organized it and all that. So, okay. Well, that's interesting. I'll find that case and put a link to it. But I mean, we are asking some big questions here, like what is a mind? What constitutes mm-hmm. a mind? Discussing photographs is really a good one, I think, as well. I mean, you are taking nature and yet you're transferring and doing things and enhancing it. So that I think that must be a big part of it, is, as you said, with the book, the graphic novel, all the enhancement and organizing that goes on. But I guess that is kind of the question: what is a mind? Mm-hmm. Is that kind of the big question?
Absolutely. And you've got. The courts right now are taking very, dry statutory interpretation. What does the statute say? The statutes require a human author. The statutes require a human inventor. But the bigger question, is kind of the thing of science fiction. That's what a lot of people are really interested in is, okay, you have these autonomous systems and they're becoming more autonomous. When do they cross the line into being more than just a computer tool, to being more than just software. I think a lot of those questions will have to be answered at some point as they become more and more autonomous, more and more sophisticated. It always brings to mind, it was probably in the early 90s, there was an episode of Star Trek The Next Generation where Lieutenant Commander Data, the android, came to the attention of a Starfleet researcher, and he wanted to basically download Data and dissect him and see how he worked. And so there was actually a court proceeding, a judicial proceeding, where I think the episode was called The Measure of a Man, where they decided whether Data was an autonomous entity who had legal rights, or was he just a piece of hardware that could be disassembled and downloaded. So, luckily for all the Star Trek fans, he was not disassembled and downloaded, and they decided that he had legal rights.
Yeah.
But at some point, right now, I think the software, artificial intelligence engines don't know what they're doing. They're very, very, very sophisticated mathematical programs that can imitate human speech and imitate, text. You think of ChatGPT and the very, very sophisticated things it's doing, but it doesn't know what it's doing. It is, working on mathematical rules, very, very complicated mathematical relationships, but is an AI system sentient yet? And I think we're a long way from that.
Yeah.
But you're right. I think at some point that will have to be answered.
Yeah. Pay attention to sci-fi. And two, I had a law professor on one podcast and a judge on another, and they're talking about, can you plug case facts and law into a machine and have it spit out a ruling? Of course, in both cases, I said, of course, a human being will want to review that. And I'm blown away by, Google Bard, and its grammar is excellent. Just asking questions, it's like, wow, it does sound like somebody actually wrote that. It's pretty good.
Yeah. If you train those AI engines on good data, they can replicate the quality data that you've provided, but they don't know. I mean, like ChatGPT predicts what the next token or the next word should be, but it doesn't know the meaning of it. It just knows based on the data that I've reviewed and statistically, and with the temperature adjusted, and what the next word should be, and it does that one word at a time. But it doesn't know what that word means. So that's how, there was another decision that came out last week of an attorney relying on ChatGPT and filing a brief that had essentially made up case sites in it. At this point, the ChatGPT knows that the next word should be part of a site, but it doesn't know what a case says. It doesn't know if it's correct. It doesn't know if it's true. Yeah. And so I think we're a long way from having all the lawyers put out of business by ChatGPT, because we actually know, we vet something. We know if it's true. We know if it's accurate. We know what we're saying. Right. And at least at this point, ChatGPT and anything like it doesn't actually know what it's saying.
Yeah. A conclusion that I've come to, speaking of lawyers using it or anybody using it, when you point it at your own data, and it can organize your own data, and it's predicting based on what you've done before, I mean, that seems more reliable and less risky. So it's like, rather than, I've had it point at articles I've written, it does a nice job putting them together, but I know where everything came from. So, and I would always disclose it that I used that assistance. And I did look for cases. Somebody asked me about a couple of cases once, and I was looking for them, and it was ChatGPT. It spit out like 3 or 4 cases, and they sounded like cases. And they said where they were from. They did not exist. They simply did not exist. And a paralegal who was really good at this. I'm good at legal research, and this paralegal is way better. And they were being kind. They said, well, maybe it's a small court, maybe in a county that's what. I'm like, no, it didn't happen.
That is a risk, and that is a big risk right now.
Yeah. But I think it's always, and I know there are people coming up with rules, but always check it on the way out. Always check
absolutely.
it. Yeah.
Absolutely.
Well, before we go, are there any other recent rulings that you wanted to mention that anybody should know about? I think we just kind of put that in there just
Oh,
in
sure.
case.
I think the other big issue, like all of the cases we've been talking about now uh, during our conversation, are how does patent law and copyright law apply to the outputs of an AI system? But there's a lot of cases right now about how particularly copyright law applies to the inputs to an AI system. So there's class actions. Everyone from John Grisham to Sarah Silverman
Right.
have filed lawsuits about their copyrighted material being used to train artificial intelligence. And so, the theory is, look, I'm the author of 20 books, 25 books.
Mm-hmm.
I think John Grisham's one of the plaintiffs, so it's probably a lot more than 20 or 25. But
Mm-hmm.
Sarah Silverman was the author of, I think, one prominent book that she said was basically copied input into the AI engine, and then the AI engine can basically appropriate her creativity, her
Mm-hmm.
style, her words, and then create material that will compete with her.
Mm-hmm.
And so a lot of those cases are very early on, saying, look, is that a copyright infringement? Are you violating those authors' copyrights
Right.
when you're digesting their information, their works, and then outputting a novel in the style of John Grisham?
Right.
And so those are going to be working their way through the courts and through the appellate courts, I would say, over the next 2 or 3 or 4 years. And those questions will have to be answered. Right now, just in the very early motions to dismiss stage, the courts are narrowing those cases and trying to determine, okay, have you alleged just the elements of a copyright infringement here?
Mm-hmm.
And then that's going to be decided in the near term in the trial courts, and then the appellate courts will have to kind of decide what the law is and should be on those.
Yeah. Yeah. Mimicking art. And when I was in college, we had a writing class that one of the assignments was to write like a famous author. So write
Mm-hmm.
something like Kurt Vonnegut would write.
Mm-hmm.
And so we would do that. And then some people were really, really good at it. But I'm sure you could train. You could
Mm-hmm.
train AI to look at the speech patterns, like you say, just predicting words. Well, this is
Mm-hmm.
typically the kind of words Kurt Vonnegut would use, and his head would spin if he were still alive. But um,
Yeah.
and also too, when they pull things from the internet, there's enough Sarah Silverman interviews and her stand up and stuff and excerpts of the book that were mentioned in reviews. Yeah, you could piece it
Mm-hmm.
together. So it's crazy, and I think too, wasn't that a part of the actors saying, they could use your image forever. Oh, I think it was extras, background people.
Correct. Right.
Like
Right.
clip art. We'll just stick you back there now.
Exactly. Exactly. And so the description you gave kind of raises the types of questions that are being asked. So if you have an AI engine and you copy a copyrighted work and input it into the engine, that's you've copied it. So that's potential copyright infringement. And the issue there that, there's some cases going back to the 90s that have to do with video game programs and whether you can make an intermediate copy of a piece of software in order to create compatible games and things like that. And so the courts are looking at whether that intermediate copying is a copyright infringement in the case of training an AI. And so you've got that input question, and then the output question. The big threshold they're going to have to pass is typically for a copyright infringement, there has to be substantial similarity. So if you take a copyrighted painting and copy it, just copy all of its elements, but create a reproduction of it, that's a copyright infringement. But if you don't take those elements and, like you were just saying, create a painting in the style of another artist, but you're not incorporating specific elements, that's much harder to show that's copyright infringement because it doesn't have substantial similarity. And so those are the questions here. Is the output of the AI substantially similar to the copyrighted work that you're alleging is infringed? And so all of those are going to have to be answered based on the facts of the individual cases that are working their way through the courts. And then, at the beginning of the internet, the courts created the whole new set of laws on, copyright over the internet, privacy over the internet, all these new and novel issues when the internet came up. And there's really that broad of an arrangement of laws now that have to be determined with AI. Everything from training it, how it's written, and then what it outputs. How do the existing laws apply to those? And do the existing laws need to be tweaked,
right,
to address artificial intelligence? Because it really is, such a wholesale change in the way content can be generated, the way that copyright material can be used to generate new content. Does the statute need to be tweaked a little bit? So I think we'll be looking at that for many years.
Yeah, I'm sure it's going to be changing. There'll be a lot coming down in the coming months and years. So I'll have to get you back on here because I know we'll have more to talk about. Yeah.
Oh, I'd love it.
Yeah. All right. Well, Rob McFarlane, thank you very much for talking with me about this today. It's a really interesting subject.
Oh, it's been my pleasure. Thank you for having me.
That concludes this episode of the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, VLEX Fastcase, and our friends at Lost G Media. I'm Tom Hagee, your host, which would explain why I'm talking. Please feel free to reach out to me if you have ideas for a future episode, and don't hesitate to share this with clients, colleagues, friends, animals you may have left at home, teenagers you've irresponsibly left unsupervised, and certain classifications of fruits and vegetables. And if you feel so moved, please give us a rating. Those always help. Thank you for listening.